Minutes.
I'm on high demand, so I beg to leave the court. I'm going to deal with some other matters.
My Lord, just a clarification whether Kituo cha Sheria was enjoined. Last time Dr. Minwa made an application for Kituo cha Sheria to be enjoined, and then you enjoined Dr. Minwa himself.
Yes, that was done.
Yeah.
Yes, Kituo appears now as seventh interested party. I proceed?
You
5
have
minutes.
your name?
My name is Mosongo. I proceed?
Yes, please.
Thank you so much. Your Lordship and your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intentions at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my few minutes. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that their right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that your Lordships and your Ladyship, to ensure that their constitutional right to fair trial, even including during this process, so just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies.
Yes.
My apologies. My apologies. Your Lordships and your Ladyships. Your Lordships and your Ladyships. If I may proceed. It is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because it said, ukiona cha mwenzako, kichwa cha mwenzako kimenyolewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, your Lordships and your Ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the Lordships and the Ladyships to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice was not served. It's imperative that at all times justice be seen to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm will be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their right before the final outcome of this honorable court. I humbly pray that your lordships and your ladyships, please do not vacate the orders. Thank you so much.
Thank you very much, Presiding Judge and the members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are.